Shall we start?
Yes, sir. Good evening, ladies and gentlemen. My name is Angad Singh, and today we are back with another webinar of the Law Club. Today we have with us speaker, Mr. Advocate Umesh Shetty, practicing counsel at Bombay High Court and various tribunals. And today he is going to speak on analysis on the evolution of the Insolvency and Bankruptcy Court. So we welcome you to our session, and I yield the floor to you, sir.
Thank you. Good evening, all of you. The topic that we have chosen to speak, as said by the moderator, Mr. Angad Singh, an analysis on evolution of IBC. As we all know, the IBC code is one of the most radical and progressive legislation of our times. The necessity of this code arose because, as experienced by all of us, there was an absence of single law dealing with various types of insolvency, such as insolvency resolution process of corporate debtors, insolvency of individuals, etc. There were different legislations, such as for individual insolvencies, one had to go to civil courts under the Provincial Insolvency Act or the Presidency Insolvency Act, whereas in the case of winding up of companies, one had to come to High Court or District Court, as the case may be. Then we had SICA, which was enacted with the purpose of restructuring sick industrial companies, where again BAFR was authorized to adjudicate the issues thereunder. Now this led to several complications, and instead of giving a solution, early solution for insolvency cases, the process got inordinately delayed. The monies, huge amounts of the loans given by lenders got stuck, and an increasing need was felt to have an efficient legislation for dealing with the insolvency cases. And the result was enactment of IBC code. After the IBC code was enacted, between the period 2017 to 2020, I would say, 4 enactments, 4 amendment acts were enacted, whereby certain important provisions got incorporated into the IBC, I would say, code, and certain additional provisions were also incorporated. Further, in addition, several judicial pronouncements clarified several issues under the Act. Now, this also added to the evolution of IBC. In effect, the IBC got evolved largely due to these 4 amendment acts and the judicial pronouncements of the Supreme Court from time to time, and NCLAT, that is NCLAT. Now, if I have to discuss each and every amendment which came in through these acts, I don't think the time allotted by the coordinators would be sufficient. Therefore, my endeavor would be take you all through important aspects of these amendments which resulted in incorporation of certain important sections and amendment of certain sections, and legal issues or the concepts which got cleared by the judicial pronouncements from time to time. So that would make it a bit interesting, I hope, instead of a boring exercise and journey of amendment acts. So first amongst these provisions which got incorporated into the IBC code by the Amendment Act is, which I would like to discuss, is Section 29A, which was incorporated by the First Amendment Act of 2017, which became effective from 23rd November 2017. So Section 29A is one of the most important sections which has given a lot of teeth to the code, I would say. Now, after the code came into effect, the experience showed that many undeserving persons, the persons who were responsible for the downfall of the corporate debtor, in fact, the persons who were instrumental in borrowing huge amounts of loans from institutional creditors and then duping them through the corporate debtor, themselves by a backdoor method, tried to take back the reins of such corporate debtor by proposing to be resolution applicants. Now, to arrest this trend, need was felt to bring in a legislation or to bring in an amendment which should prevent these wrongdoers from taking back the reins of the corporate debtor. Therefore, Section 29A and Section 25(2)(h) got incorporated in the code. Now, Section 25(2)(h), prior to its amendment as it stood, that is 25(2), did not have any specific qualifications for becoming a resolution applicant who could submit a resolution plan. Anybody could have submitted a resolution plan, and the resolution professional, RP as we call, did not have much choice to say that A is ineligible or B is ineligible because of certain factors or certain reasons enumerated in the code itself. So it became a free-for-all situation, where, as I said, the wrongdoers started putting their foot in and they were trying to seek an entry through the back door in the resolution process. Now, 25(2)(h) came out with the eligibility criteria, I would say, which went on to state that a resolution applicant would ensure that the resolution plan conforms to the requirement prescribed by the committee of creditors depending upon the exigencies, nature of business, etc. of the corporate debtor, broadly speaking. Now, in contrast to this, Section 29A came out with the host of ineligibilities which would disentitle a a person from becoming a resolution applicant. Section 29A curiously opens with the words, any person acting jointly, any person acting jointly in concert with other persons. If to read it correctly, a person shall not be eligible to submit a resolution plan if such person or any other person acting jointly or in concert with such person. Then it goes down to set out the various ineligibilities from clauses A to H, A to J rather, I would say, of Section 29A. Effectively, it says either a person himself who proposes to be a resolution applicant and comes with a resolution plan, or any person jointly acting with that person or in concert with that person, if it suffers from any disabilities, then also the person who wanted to become a resolution applicant would be disentitled. Now, the ineligibilities set in there are a person if he is an undischarged insolvent, or a person is a willful defaulter as provided in accordance with the norms set in by RBI, or at the time of submission of resolution plan has an account which has become NPA, or is a promoter, director, etc. of the corporate debtor, which has become NPA and remained NPA for a period of more than 1 year or so, for a period of more than 1 year. These are the ineligibility set out in clauses A, B, C. Now, there are further ineligibilities which goes on to say that if a person is convicted for any offense for a period of 2 years or more under specific acts mentioned in 12th schedule of the code, or for a period of 7 years under any other law, or if a person has been banned by SEBI from trading in securities, and or a person has executed a guarantee in favor of a corporate debtor, and against such corporate debtor, a resolution process, insolvency resolution process has been initiated by a creditor, and that guarantee has remained undischarged. In effect, if a person has not discharged his obligations under the guarantee, even that would be a disqualification. And now these are the various ineligibilities set out under section 29A. I would not go into each of it. Now, the sum and substance of this section is that it is not alone, as I said, at the cost of repetition. It is not alone that a resolution applicant suffers from some ineligibilities, even if some persons who are acting jointly or in concert with him suffer from such inabilities, the resolution applicant would be disentitled from submitting, the proposed resolution applicant would be disentitled from submitting a resolution plan. Now, of course, this section has got some curing provisions in the sense, so far as clause C thereof is concerned, which speaks of, as I said, NPA remaining NPA for a period of more than 1 year. If the debts or the dues are paid by the concerned person, then that person can submit a resolution plan. That defect gets cured. Then there are some exceptions provided, such as the financial entities described thereunder, who and subject to the conditions mentioned therein, they would not have these ineligibilities which are specified under the particular subclauses, subject to the conditions, of course, specified therein. Now, the validity and the virus of this section came for consideration firstly under ArcelorMittal's case by versus Satish Kumar Gupta by the Supreme Court. Now, in that case, as rightly noticed by Supreme Court, this section is based on the principle of lifting the corporate veil of a corporate debtor. In the sense, as I said, that this section permits the adjudicating authority to go beyond the identity of a resolution applicant and to see actually who are the persons behind it. Either resolution applicant or the persons acting jointly or in concert with such a resolution applicant, the adjudicating authority is entitled to lift that corporate veil and to see actually the persons behind it suffer from any of the ineligibilities mentioned under section 29A. The Supreme Court in that ArcelorMittal's case went on to state that where a statute permits lifting of corporate veil or where protection of public interest of paramount importance demands, or where a company has been formed to evade obligations imposed by the law, the court would disregard the corporate veil. This is the ratio of ArcelorMittal judgment delivered by the Honorable Supreme Court. Now, the validity of this section once again fell for consideration in the case of Swiss Ribbons Private Limited versus Union of India. Now, in this case, the Supreme Court went on to consider the expressions such as related party as defined under section 524, where corporate debtor, related party in relation to individuals, 524A, and relative as defined under explanation 1 to section 524, and went on to state that these expressions should be read nocitur associates with the categories mentioned in clause 2 of explanation 1 to section 29AJ of the code. I would explain it in simple words. The sum and substance of the Supreme Court judgment is that the terminologies, related person, related party, etc. used in the code, in the definition expressions, when it comes to implementation of section 29A, should be telescoped into explanation 1 to section 29AJ of the code, which I would read out quickly. Section 29AJ, explanation 1 to the, explanation 1 to section 29AJ says, for the purpose of this clause, the expression connected person means any person who is the promoter or in the management or control of the resolution applicant, or any person who shall be the promoter or in management or control of the business of the corporate debtor during the implementation of the resolution plan, or the holding company, subsidiary company, associate company, or related party of a person referred to in clauses I and 2. I 1 and 2, sorry. The Supreme Court says that those definitions, which I said, related party, etc., should be read along with clause 2 of explanation 1 of section 29AJ, which says any person who shall be the promoter or in management or control of the business of corporate debtor during the implementation of the resolution plan, which means, to make it simple, to attribute ineligibility to a person, it is not enough if that person is only related to or relative of a person who suffers from ineligibilities mentioned in section 29A. Mere blood relationship is not enough to disentitle a proposed applicant on the ground that he is a relative of some person who suffers from ineligibilities mentioned under section 29A. What is required is a business relationship of that person or of that relative with the person who suffers from ineligibilities, and that would be the criteria. Now that criteria also, it goes to say that he should be related to a person or vice versa who shall be the promoter or in management or in control of the business. Means if a person is related to a promoter or a person who is in management or control of business, and such person suffers from ineligibilities, then the relative would be disqualified. And if the relative suffers from the ineligibilities mentioned under that clause 2 of explanation 1 to section 29A, the person who wants to become resolution applicant would be disqualified. It's a clause which operates both ways, either against relative of a person who wants to become a resolution applicant or a person who wants to become a resolution applicant. But the criteria is there should be a business relationship between the two. It is not enough that there's a blood relationship. Now, section 29A thus got enacted, and to ensure that undeserving persons do not get back the control of a corporate debtor, the persons who are actually responsible for the downfall of a corporate debtor should not have the benefit of getting back the control of such corporate debtor. This is what, in sum and substance, the purpose of section 29A. Now, while we are on this section 29A, it would be necessary to refer to proviso to section 35. Now, section 35 prohibits the sale of movable and immovable properties by a liquidator or actionable claims, of the corporate debtor by a liquidator to any such person who suffers from any of the ineligibilities mentioned under section 29A. So the ineligibilities prescribed or mentioned under section 29A would haunt such person even at the stage of liquidation of a corporate debtor. He won't be able to buy the assets of a corporate debtor even when it goes to liquidation at the end of the day. So he's ousted at all levels. Now, having said this, while we are on this, I would say that section 30 bracket 4 casts an obligation on the concerned COC to ensure that the resolution plan, the resolution plan is not submitted by an applicant who suffers from any of these ineligibilities, and that it conforms to the requirement prescribed under section 30 bracket 2. Now that is so far as the eligibilities and ineligibilities of the resolution applicant in the process of insolvency resolution process are concerned. Now we go to the second amendment. Now in the second amendment, what is important to be seen is incorporation of clauses C and H to section 29A of the code. This is very important because clauses C and H, as I said earlier, clause C speaks of an ineligibility when an account of the concerned person becomes NPA and remains so for a period of 1 year or more. Now, clause H speaks of the undischarged obligations of a guarantor under a guarantee in respect of a corporate debtor against whom the insolvency resolution process has already been initiated and the guarantor has effectively failed to discharge his obligation. These are two ineligibilities out of the several ineligibilities mentioned under section 29A. Now, what section 240A does, section 240A goes on to state that the clauses C and B of section 29A would not be applicable to any micro, small or medium enterprises as defined under Micro, Small and Medium Enterprises Development Act 2006. Let me tell you in short, the ineligibilities under clause C and H of the code would not render ineligible a resolution applicant if such resolution applicant is a MSME. In other words, if a MSME is taken for insolvency liquidation process and any of its promoters or directors who otherwise were ineligible to be resolution applicant because of clause C and H, such ineligibility would not be an obstacle for them to become a resolution applicant in the case of a MSME. Now, this is a very progressive step, and this section 240A came up for consideration, and the validity thereof was considered in the case of Swiss ribbons by Supreme Court, and the Supreme Court was pleased to uphold the validity thereof in that case. The reason being that in the case of a MSME, unless an early resolution process, a resolution plan is approved, and unless the MSME is brought on track quickly, there is every possibility that it going up for insolvency, for liquidation. Now, if a MSME goes for liquidation, experience has shown that there are very few takers to take it as a going concern, and as a result, the MSME would perish. The MSME sector would be badly affected if these exemptions were not granted. And therefore, to see that the MSME sector is protected, as MSME sector is a backbone of the industrial setup of any country, legislator took a very, very conscious step to incorporate section 240A and exempt MSMEs from the application of subclauses C and H of section 29A. It's a very, very welcome step, I would say. The next topic what we would go to discuss is that under the Second Amendment Act, the flat allottees were allotted to the status of financial creditors by incorporating an explanation to section 5(8)(f). As we know in our country, and particularly in cities like Mumbai and Delhi, there are instances when the allottees book flats in advance, and at the end of the day, the building doesn't come up. The monies are not repaid to such allottees. And those allottees are required to run from pillar to post to get back their monies. The legal process in courts is extremely time consuming besides being expensive. And as a result, these innocent allottees are left in lurch with no remedy at their disposal, which would bring quick results. Therefore, to help out these allottees and to ensure that they get their monies refunded at the earliest from the concerned developers of the real estate projects, the explanation 2, I would say, to section 5(8)(f) was amended, whereby the monies paid by allottee to a real estate developers qualifies to be a financial debt. Now, if it qualifies to be financial debt, in turn, as per the definition of section 5(7), the allottee becomes a financial creditor. Now, when he becomes a financial creditor, he becomes entitled to invoke the provisions of the IBC, and he can become a part of insolvency resolution process, and he can be a creditor who can participate as a member of COC in all its decisions. That makes a huge difference to the status of an allottee once he gets elevated to the status of a financial debtor, a creditor, I'm sorry. So this was challenged in the case of Pioneer Urban Land Infrastructure Limited versus Union of India. This amendment, this elevation of the status of allottees to that of financial creditors was challenged, as I said, in the case of Pioneer Urban Land and Infrastructure Limited. The Supreme Court in that case upheld this amendment and also upheld the rights of the allottees to be a part of COC. In that case, incidentally, the Supreme Court went on to state that the provisions of RERA and IBC operated in separate fields, and RERA did not conflict with IBC. But if at all RERA clashed with IBC, then RERA has to give in to IBC. In effect, in this judgment, the Supreme Court upheld the supremacy of the IBC court. Now, this was so far as the elevation of status of allottees to the financial creditor as it stood by virtue of this amendment to explanation 2 to 5(8)(f). However, subsequently, a further amendment came by way of incorporation of a proviso to section 7. Now, this proviso provided to the effect that the allottees can initiate, the allottees of flats could initiate the provisions under the IBC code, the insolvency resolution process, etc. only if they are 100 in numbers, or if they are more than 10% of the total number of allottees of that very project, whichever is less. Now again, this had a very important object. Experience showed that for no justifiable reasons at times, a single allottee would try to pressurize the developer of a project, and only with an intention of extracting some money or some purposes known to him, and thus would hold the entire real estate project to ransom, subjecting several other allottees to inconvenience. So this needed to be avoided, and to avoid such difficult situations, the amendment by way of a proviso to Section 7 got incorporated, which mandated that at least, as I said, 100 allottees or 10% of such allottees, whichever was less of the same real estate project, could invoke the provisions of IBC. Now the time is running out, so I'll try to rush through. There's another important amendment which got incorporated by way of subsections to Section 12, 30 and 33. That is Section 12 bracket 2, Section 30 bracket 4 and Section 33 bracket 2. Now these are in relation to extension of time limit for completion of CARP, that is Corporate Insolvency Resolution Process, under Section 12 bracket 2. Section 30 bracket 4 is in relation to approval of resolution plans, and Section 33 bracket 2 is for taking decision to liquidate a corporate debtor. Now for taking these decisions, prior to amendment, the majority required was 75% majority of COC, that is Committee of Creditors. However, it was seen that at times a good resolution plan got obstructed by a small minority of dissentient financial creditors or corporate debtors, and as a result, the insolvency resolution process got inordinately delayed. To avoid this situation, it was thought fit to bring down the requisite majority from 75% to 66, so that this would improve the efficiency of finalization of the insolvency resolution process. Now, can you hear, Angad? Angad, can you hear? Angad, can you hear me? Am I audible, Angad? Can you hear me? Okay.
Oh. Yes, sir, we can hear. Please continue.
Okay. Now, the next topic I would touch is, after discussing these amendments, an important amendment came in by way of Section 14(3) to the IBC code. Now, as per this amendment, the moratorium benefit which is available to a corporate debtor upon initiation of a corporate insolvency resolution process is denied to certain transactions which may be prescribed by the concerned authority, or and I would say to a guarantor of a corporate debtor. Now this is an important provision in the sense that one may argue that the guarantor's liability is joint and several, and therefore if a corporate debtor enjoys moratorium, the guarantor as well is entitled for such moratorium. Now however, the legislature thought it fit to deny such benefit to guarantor, as his liability was considered to be independent of the corporate debtor. As you would know that on several occasions in the past, the suits used to be filed independently against guarantor. Based on the same analogy, it appears the benefit of moratorium to a guarantor has been denied. Now, this section, the validity of this section was considered by the Supreme Court in the case of SBI versus Ramakrishnan, as well as Committee of Creditors in SR Steel versus Satish Kumar, and the validity of this section was upheld by the Supreme Court. Now, while we are on this amendment to section 14, it might be necessary to have a quick reference to Gazette notification dated 15/11/2019, which brought into force section 2E, in the sense, as per this notification, the section 2E became effective. In other words, so far as the guarantor is concerned, the IBC code became effective, and various sections such as section 78, 79, and sections 94 to 187 under part 3 to part 7 of the code were brought into force. The net effect of these sections would be read in the light of section 60(2) of the code is that while under section 60(2), if a CIRP or the corporate insolvency resolution process is initiated against a corporate debtor, one can initiate insolvency resolution process against the guarantor of such corporate debtor before NCLT, be it a corporate guarantor or personal guarantor. The question arises, what is the situation if no corporate insolvency resolution process has been initiated against the corporate debtor, but the creditor wants to initiate an independent resolution process against the personal guarantor of such corporate debtor? In my view, if the guarantor is an individual, then by virtue of these various sections which I mentioned having come into force, which also include a mention of adjudicating authority as DRT in the case of insolvency resolution process meant for individual debtors or partnerships or the partners of such partnership firms. In the second scenario, what I said, that where a corporate insolvency resolution process is not initiated against corporate debtor and a creditor wants to initiate insolvency resolution process against individual creditor, in the light of the developments which took place because of the Gazette notification dated 15/11/19 bringing into force the sections what I mentioned, one can go to DRT to initiate an insolvency resolution process against the individual personal guarantor of the concerned corporate debtor. So the next amendment, which is an important amendment, is incorporation of section 230A. Section 230A proceeds to state that the provisions of Limitation Act would be applicable to the court. The effect of this section is that any applications which involves a cause of action dating back for a period prior to 3 years from the date of filing of an application before NCLT would be barred by law of limitation. In other words, this section would be, in my view, it can be safely called as a retroactive provision, as it affects the existing applications also. The validity of this section was considered in the case of BK Educational Services Private Limited versus Parag Gupta by Supreme Court, where the Supreme Court made it clear that even the existing applications under section 7 and 9 would be affected by this section, and article 137 would get attracted to such applications. This legal position was once again affirmed by the Honorable Supreme Court in the case of Umesh Shah versus Union of India, which got decided on 25th September 2019. Now then, I will not touch all amendments for lack of time, but some of them I would certainly discuss. Section 12A, which got incorporated, permits withdrawal of application under section 7, 9 or 10 if 90% of the majority of the COC permits such withdrawal. Prior to incorporation of this section, there was a lot of uncertainty with regard to the powers of NCLT permitting such withdrawal. Now this uncertainty has been put at rest. Now we come to another important section, that is extension of timeline prescribed under the IBC code. Section 12.3 as it stood prescribed a time limit of 180 days for CIRP process, that is insolvency resolution process, and for extendable by a period of further 90 days if it was necessary, if it was found necessary. Now this amended section has extended this time limit, in the sense increased this time limit for disposal of CIRP process to 330 days, with the further proviso that it can be extended for a further period of 330 days, but further period of 90 days, but subject to a caveat that this would also include time taken for litigation. Now, this section also, as it was enacted, or when it got incorporated, had the word mandatorily, in the sense the CIRP process as per this section was required to be mandatorily completed within a period of 330 days and extendable by 90 days. Now this validity of this section fell for the consideration of the Honorable Supreme Court in the case of SR Steel versus Satish, in the case of COC, that is Committee of Creditors of SR Steel versus Satish Kumar Gupta. In that case, the Supreme Court did uphold the validity of this section, but at the same time went on to state that the word mandatorily appearing in that section was violative of section Article 14 and Article 19 1G of the Constitution, and in that case the Supreme Court struck down these words mandatorily as it was appearing in that section. Now therefore the effect of this judgment is, though this judgment prescribes 330 days as an outer limit extendable by only 90 days, in appropriate cases it is open for the adjudicating authority or the appellate authority, as the case may be, to extend the timeline required for completion of the corporate insolvency resolution process by suitable time, after taking into account the factors such as time taken in litigation, for which the litigant may not be actually responsible, and if there are any other justifiable reasons, it is always open for the authority to extend the time. Now, another important amendment is in connection with the section 14.1, which provided for moratorium. Section 14.2 of the Code says, it has a mandate in fact. It says the supply of essential goods and services will not be suspended or terminated during the period of this moratorium. A very strong language is used. Now, this mandate, the question, as far as this mandate is concerned, the question that bothers me is, to whom this mandate is binding? Whether it is binding on the resolution professional, or whether it is binding on the concerned suppliers who are responsible to supply the goods or services. This, again, I would say that this section is subject to a caveat that the corporate debtor should be able to pay for such goods and services. As I said, this contains a mandate, and in my view, since the proceedings under the IBC code as held by Supreme Court is proceeding in rem, in the case of Swiss ribbons, the Supreme Court went on to state that the proceedings under the IBC are proceedings in rem. If it is a proceeding in rem, in my view, this mandate would be binding on all the concerned, including the suppliers, to ensure that, subject to their receiving payment, supply of essential goods and services kept on during the period of moratorium, and the same is not suspended or terminated. Next, we come to incorporated section 32A, which grants immunity to the corporate debtors from the offences which it might have committed during the prior to the insolvency period, prior to the starting of insolvency resolution process. However, this immunity is subject to a condition that the corporate debtor should not be under the control or management of the promoter or a director or some officer who was there at the relevant time prior to the CRP process when the corporate debtor had committed offense. In other words, the immunity is available to a corporate debtor during the CRP or the insolvency resolution process, provided the corporate debtor is not controlled or managed by the very wrongdoers under whose control or management the corporate debtor had committed some offences for which some investigation might be pending. Having said this, that is, I feel that keeping the time available in mind, sufficient discussion on the amendments to the code. Now, quickly, I would like to discuss some of the concepts, that is classification of creditors, that is financial, under the code, as you know, there are mainly two types of creditors, that is financial creditors and operational creditors, as defined under section 5, 7 and 520 respectively. Now, while the financial creditors are conferred with rights, including the rights to become members of the COC, that is Committee of Creditors, and Committee of Creditors, which takes various important decisions. The operational creditors would not have such rights. Now, this classification was considered and upheld again in the case of Swiss ribbons. The rationale behind this classification is, while the financial creditor lend assistance to the concerned corporate creditor right from the inception, right from the beginning when the corporate debtor comes into existence, and they nurture it during its initial years, and they are very much interested to see that viable, workable insolvency resolution process is worked out so that the corporate debtor would be back on its feet, and all the concerned would get their monies back. Also, the corporate debtors, the operational creditors may not be really interested in reviving a corporate debtor. All that they may be interested is a refund of their monies. Therefore, the operational creditor, as held by the Honorable Supreme Court, cannot seek parity with financial creditors. There's one more difference between the financial creditors and operational creditors. So far as the financial creditors are concerned, mere existence of a default by the corporate debtor as provided under the code would be sufficient. But when it comes to operational creditors, undisputed debt is a sine qua non, as held by the Supreme Court in the case of Mobilox, which followed the earlier case of Inventive. And unless there is an undisputed debt, an operational creditor would not be entitled to initiate insolvency resolution process against the corporate debtor. Again, an operational creditor is required to give 10 days notice to the operational creditor for invoking the provisions of the code, as compared to this, a financial credit. In the case of financial creditor, this requirement is not there. Now we come to the last of the topic, that is group insolvency and consolidated insolvency resolution process. The experience has shown that or rather I would say that necessity is mother of all inventions. After the IBC code became functional, experience showed that in large number of cases, a group insolvency or a consolidated insolvency resolution process became necessary. Now, faced with this situation, the question arose that whether it is permissible. I would say that there is no specific provision under the code which would permit group insolvency or consolidated insolvency resolution process. However, under section 60 bracket 5, which is the fountainhead of the residuary powers of 60 bracket 5 bracket C, which confers residuary powers on the adjudicating authority, that is NCLT. NCLT would be entitled to permit consolidated insolvency resolution process or group insolvency, as the case may be, after evaluating all the factors, as held by NCLT in the case of SBA versus Videocon Industries and others, and in other connected matters. Factors such as common control, common director, interlacing of finance, pooling of resources, intricate link of subsidiaries, singleness of economics of units, and several such other factors such as common financial creditors, etc., would be the factors for permitting consolidated insolvency resolution process. It is also held in that judgment that the comparative benefits, if they outweigh the inconvenience caused to some, it would be a proper and appropriate to permit a consolidated insolvency resolution process. In some other cases also, the group insolvencies has been permitted, while in one of the cases, that is Vishnu Kumar's case, the group insolvency, Vishnu Kumar Agarwal versus Pyramel Enterprises, the NCLT had declined to permit a common Section 7 application against two corporate guarantors on the ground that if you once invoke the provision or once you file an application under Section 7 against one of the corporate guarantors, you can't file a Section 7 application again against another guarantor for the very same debt. The correctness of this decision is debatable. However, the fact remains that this decision was challenged in Supreme Court, and the Supreme Court has stayed the judgment of the NCLT in this matter. To conclude, I would say that IBC code is one of the most radical and progressive legislation of our times. It has been enacted mainly, apart from other purposes, as I said, to ensure that the asset valuation of the corporate debtors is maximized and the resolution gets maximized, and the resolution process works out to the benefit of everyone and ensures that the concerned corporate debtor is back on its feet as a going concern. However, due to some teething problems, I would say that the stated objectives are not fully achieved so far, but we are in the process of achieving the same. And I am hopeful that this code would help and a quick resolution of the insolvency resolution processes of the corporate debtors, and would be a catalyst for the economy picking up and the money of the institutional creditors coming back in the system. Thank you.
Right.
Thank you, Angad.
Thank you, sir, for such an informative session, sir. Sir, if I could just take a couple minutes of your time, sir. There are a few questions regarding the topic, if you would be willing to answer.
Yeah, if I will try to answer them to the best of my ability.
Right. So I'll start from first. The first question is a moratorium applicable to a pending writ petition against the corporate debtor?
Come again, is the moratorium?
A moratorium applicable to a pending writ petition against the corporate debtor?
Yeah, the language of section 14.3, if I may refresh and read it for the benefit of everyone. Section 14.3 says, Section 14(1), I'm sorry. Subject to the provisions of subsection 2 and 3 on the insolvency commencement date, the adjudicating authority shall by order declare moratorium, prohibiting all of the following, namely institution of suit or continuation of pending suits or proceedings against the corporate debtor. So the proceedings, in my view, should include writ petitions also.
Right. Thank you, sir. The next question. Can a resolution applicant withdraw from his offer which is approved by the COC? Basically, the COC has approved a resolution plan, but before the resolution plan is approved by the NCLT, can the resolution applicant withdraw the offer?
You mean the resolution applicant could withdraw?
Withdraw.
Coming in, please, with the question.
Could the resolution applicant withdraw his offer if his offer is approved by the COC, but it has not been approved by the NCLT? Or not yet approved by the NCLT?
I would say that till it's section 30(2), if one sees, because this question came in one of the cases, I believe, before Supreme Court. Section 32 casts an obligation on the resolution applicant to consider the plan, and then 31 speaks of approval of resolution plan by the adjudicating authority. Now, in my view, before the adjudicating authority approves, there should not be an impediment on the part of the resolution applicant to withdraw his plan, strictly speaking, because there is no prohibition under the code.
Right.
There is no prohibition. Now, you can't compel a resolution applicant to go ahead with it. So therefore, in my view, prior to it being approved by the adjudicating authority, the concerned applicant can withdraw his application, his plan.
Okay. Right. All right. Final question, sir. Can an RP table a resolution plan which is not compliant with Section 29A for discussion in the COC?
Now, I would say that under Section 30(2), under Section 30 bracket, just give me a minute. Yeah, under Section 30(2), a resolution applicant, a resolution professional RP is bound and obliged to ensure that the resolution plan conforms to the requirements of the code, including Section 29A. He will be failing in his duty if he doesn't ensure that the plan conforms to the requirement of 29A. So, in my considered view, that it would be a breach of his obligations under 30(2) if he tables a resolution plan which is in violation of Section 29A.
Okay. Right. That is very enlightening, sir. I understand there are a few more questions coming up.
No, somebody is referring to an SR judgment.
Yes, yes.
Now, SR judgment did not consider if the plan did not conform to 29A. Now, there's a difference in RP taking a decision to reject, and there's a difference in RP being required to ensure that at the threshold, it conforms to the requirement of 29A. In fact, the Supreme Court in one of those cases went on to say that if the RP rejects an application because it doesn't conform to 29A at the threshold itself, such a decision cannot be challenged by the resolution applicant before the adjudicating authority. So therefore, it is a bounden duty of RP to ensure that it conforms to the requirement of 29A and then present it to COC. He can't shirk his responsibility. Because that meaning is clear from the other connected sections also, 25(2)(h) if we see. that he is supposed to invite applications from only those applicants who fulfill the criteria.
Right.
Thank you.
Thank
Thank you
you,
very
sir.
much.
I understand, so there are a lot more questions coming, but sadly we are out of time, sir. So maybe I can conclude the session over here.
Nice.
I'm
I
sure
take this
everyone,
opportunity.
I'm sure everyone would like to ask you a lot more questions about this topic, sir.
Yeah.
But anyways, thank you very much, sir, for.
Thank you, Angad. I take this opportunity to thank all of you for bearing me out. And I thank moderator Mr. Angad Singh and Mr. Niraj Shah, coordinator of this webinar, and the law chambers of Siddharth, Mr. Siddharth Murarka and Mr. Siddharth Murarka especially for giving me an opportunity to address this seminar. Thank you so much. Thank you all of you.
Right. Thank you very much, sir. All right, and we shall be concluding this session.